Hello, good evening, and welcome to the TNT Show. Tonight, we are well into our second century of the show. I'm John Drummond, and I'm your host for the next 60 minutes. And thanks to you, the TNT Show and Indie Live are growing and delivering more exciting shows than ever before. Oh, and by the way, you can watch the TNT Show on indielive.net. It's streamed out on YouTube, Facebook, TikTok, and Twitter, and other platforms as well. Plus, if you go to the YouTube facility, you can look at all the previous shows as well. And many people do. We look at the viewing figures for past shows, and they're pretty considerable. Now you have a chance to support this vital channel. So I hope you will take the chance when you see the crowdfunder details to donate. It would be very, very helpful to have that. As I say, if you're upset about media coverage of Scottish events, where journalism in many cases has been junked in favour of stenography, if you're looking for an alternative voice, well, you found it. We're here for you. But will you be here for us? Please donate. It's very important. Well, it's been another great day for British democracy. Liz Truss began her remarks in Parliament during PMQs today by saying, "I am genuinely unclear." That's true. She said, "I'm genuinely unclear," which, in fairness, applies to almost the entire population of these islands. And Liz Truss also said, and this is not so whimsical, she says she has no intention of contacting the First Minister of Wales directly. Think about that. That's a man, Labour, elected by the voters in Wales in a clear-cut decision, and the Prime Minister of the UK is saying she has no intention of speaking with him. So much for the family of nations, you might think. Tonight, we are talking to a special guest. We'll be discussing the news from the Supreme Court, which is occupying the public prints, with Professor Aileen McHarg. And Aileen is always worth listening to. But with the Supreme Court in full swing, there could scarcely be a better time to talk with her about matters constitutional and otherwise. And she's here for a full hour. And she'll be taking your questions live. So if you have a question, use the platform. Let us know what your question is, and we'll try and fit it in as best we can. And remember, she's here for a full 60 minutes, and you've still got time to get your question considered. So TNT stands for The Nation Talks. So in many respects, this is your show. We're live and we're free. So no license, no problem. Now, to our guest tonight, The Nation Talks, to Aileen McHarg. Aileen, how are you?
I'm fine, thank you. A little bit stressed today, but otherwise very well, thanks.
Why are you stressed?
As you mentioned, the Supreme Court has been hearing the independence referendum reference yesterday and today, so I've been trying to listen to as much of that as I can, but it falls during half term, so I've got children at home and other things to do endlessly. So yeah, a bit stressed.
So with your professional constitutional expert hat on, what have been your thoughts about what you've seen and heard today at the Supreme Court?
Well, so yesterday and today, I managed to hear all of yesterday's. Today, I missed the crucial bit where Sir James Eadie argued why a referendum wasn't within the competence of the Scottish Parliament, which was a bit annoying, but I have read his written submission. So there was an awful lot. What I heard particularly today was an awful lot of very technical discussion about particular provisions of the Scotland Act. So a lot of focus on whether or not the reference should be accepted by the court, and less, surprisingly little today at least, on the substantive question: does the Scottish Parliament have the power to legislate for a referendum unilaterally without the agreement of the UK government?
I mean, it's an interesting point. I mean, I guess a lot of people are trying to follow this whole discussion. Mm-hmm. I suspect many of them find it quite off-putting if you're not a lawyer, legal niceties don't amount to a can of beans. They sort of get in the way of understanding rather than facilitate it in many respects.
Yeah, yeah. I called Hamilton's today, said he'd lost the will to live. So yes, I think quite a lot of people shared that. I mean, I wasn't particularly surprised at the focus of the arguments on very dry and technical issues. That's how I thought it would go, and that reflects the nature of the submissions made by the Lord Advocate and the Advocate General for Scotland. The SNP's submissions, as you probably know, the SNP made a separate intervention, but they were restricted to written submissions. They weren't allowed to present their arguments orally. Their arguments were a little bit more interesting because they were talking about issues like the right to self-determination in international law and the proper approach to interpreting the Scotland Act in the light of that right to self-determination. But that didn't play much, if any, role in the deliberations of the court of the past couple of days. Although there were some references, Lord Sales today was asking questions about democracy and the right, the appropriateness of facilitating the democratic process and so on. So there was a little bit of reference to those underlying issues. Yeah,
I mean, it's interesting you should say that, because I think from a lay person's perspective, it's much easier to access legal arguments through a discussion of morality, i.e., is there a moral right of self-determination? I mean, that's easy to understand. The nuances of the Scotland Act are far harder to grasp.
Yeah,
which is why I'm so glad you're here tonight, because I suspect there'll be many thousands of people saying, I watched it, I'm not sure I understood much of it. So looking back over the last 2 days, what's been your general view about not just the arguments, but the listening to the members of the Supreme Court and reflecting over their comments or questions or suggestions? Is there anything that surprised you?
I think that the degree of focus on the procedural question, are we going to accept this reference or not, is, at the expense of discussion of the substantive question, was maybe a little bit surprising at first sight, but then on reflection, maybe not so much, because the substantive question of whether the Scottish Parliament can legislate for a referendum, it's been around for a long time, it's been debated for a long time. The parameters of the debate are really very well known. Whereas this reference question for lawyers is a really novel question and actually quite a difficult question. So it's maybe not surprising that the Supreme Court justices were probing a lot more on that issue than they seem to be on the substantive issue. Perhaps they felt they understood the substantive issue better from the written submissions, and they have to make up their mind, obviously, but they don't find it tricky in the way that they obviously found that the procedural question very tricky. I mean, I tweeted at some point today, that they were getting their knickers in a bit of a twist over the meaning of paragraph 1F of Schedule 6 of the Scotland Act, and law students should take comfort from that. And indeed, here is the most senior judges in the UK, obviously really struggling with this very important but rather obscure question of law. But this obscure question of law could turn out to be very, very important in the resolution of this issue and in the course of the political debate, the constitutional debate in Scotland.
Interesting you should say that. I want to read you, if I may, from a tweet by a unionist group, which is always fun. And they are maintaining three things. And I'd like your comment on this. Leaving aside the politics of it, let's forget the source. First of all, it's got that the Scottish government will fail, and they said on three grounds. First of all, the Supreme Court will decide it's premature and it goes away. Secondly, the bill would relate to reserved matters, which is, as they put it, our constitution, and therefore you can't enact it. And so therefore it will go away. Three, yes, you can hold a referendum without UK consent, as they put it, but it would have no legal standing, and it would be simply a glorified opinion poll, and therefore it will be boycotted.
Right. Okay. So the third,
you construct that for us, please.
Yeah, the third one obviously contradicts the previous two, because something that the Scottish government has been absolutely clear about forever is that if they cannot lawfully hold a referendum under the Scotland Act, and whether that is because they can already do that, they've already got the power to do it, or as in 2014, there's an amendment to the Scotland Act. Unless that either of those things is in place, the Scottish government is very clear they will not hold a referendum because it won't work. I mean, they can't force local authority returning officers to organise a poll, to distribute polling cards, to count the votes, unless there is legal authority to do that. So I think the whole question of, this has annoyed me for quite a long time, talk of a wildcat referendum. It's not going to happen. It's either a legally valid referendum or it's not. Now, if the Supreme Court does say that the Scottish Parliament has the power to hold this referendum, I think one thing that's been really interesting, certainly in the written submissions from the Advocate General, is they accept that that referendum would be politically very important. It wouldn't be legally, it wouldn't mandate any legal result. It would be advisory or non-self-executing, to use the terminology that the Lord Advocate used. But it was absolutely central to the Advocate General's case that that referendum would be politically really important. So you can't have your cake and eat it. Either it's a lawful referendum and it's politically very significant, or it doesn't happen. There's no halfway house. There is no wildcat referendum that can be boycotted because it's unimportant.
Am I right in thinking that no referendum or referendum in the UK is legally binding? Brexit wasn't legally binding.
So the Brexit referendum wasn't legally binding. That's true. Most referendums are not. Occasionally they are. So that there's three examples where there was a binding legal effect. The two in 1979, the two devolution referendums in Scotland and Wales, and the alternative vote referendum in 2011. In both cases, had there been a vote in favour of devolution or alternative vote, it would have brought into effect the relevant legislation. However, even that could have been reversed by a subsequent UK Parliament. So, in a system where you've got a sovereign parliament, it's very difficult to say that Parliament is ever bound by a referendum result. But in most cases, it's just a result. It's just a declaration of a public opinion on the particular issue. And as you say, Brexit certainly was. And we know the Supreme Court said in the first Miller case that we couldn't leave the EU on the strength of the referendum alone. The UK Parliament had to endorse that through a further act of Parliament. Interesting.
We've had a question here. Could Aileen please talk about the inverted commas sweep up, close inverted commas, clause, I think from section 31 or 33 of the Scotland Act?
Right.
You're free to say no.
It wasn't section 31 or 33. It was paragraph 1F of Schedule 6 to the Scotland Act. Yeah, this was... So under Schedule 6 of the Scotland Act, there is a power for the Lord Advocate and the other law officers to make references to the Supreme Court of devolution issues. And there's a whole series of specific issues that are listed at the beginning of Schedule 6 as devolution issues. And then right at the end of paragraph 1F, it says, or any other question arising from this act relating to reserved matters. And the Lord Advocate is saying, well, the question I'm asking the court is a question arising from this act relating to reserved matters, so please answer it. Whereas the Advocate General is saying, no, that's not what it means. It means something much, much narrower. And a lot of the discussion today was him trying to give a plausible alternative reading of that provision, which he was being constantly questioned on by the judges. So kind of every time he had escaped one question, they came back with another question, because yeah, so yeah, that was what the whole debate is about, were those words which appear on the face of it to allow the Lord Advocate to make this reference, do they actually mean something much more specific and much narrower, which would not include this reference? I hope that answers the question.
Yeah, well, it sounded helpful to me. Thinking about the whole business of sovereignty, and what the First Minister has been saying recently, when questioned about what the verdict of the court might be, if it turned out not to be in her favour. And by her favour, I mean, we regard it as legitimate for you to have this referendum. Her view was, on that case, we'll do something else. We'll have a plebiscite, or I can't remember the exact terminology, but we will have a general election, perhaps, predicated upon one single issue. And on the strength of that, that will determine whether we proceed. I wasn't quite sure what she was going to proceed with, assuming that happened the way she wanted it to happen. What could she proceed with? I mean, what's the... Because your earlier remarks seem to me to be very clear. There's only one way to do this. You can't declare UDI. You can't have a wildcat referendum. There's only one way to do it, which is through the Supreme Court endorsing it. And if they don't, then where does she go?
Well, okay. So I mean, you could have UDI, but it's a risky strategy, right? Because UDI depends for its effectiveness on other states recognizing it, and that is taking a very, very big risk. If they don't recognize your Declaration of Independence, it hasn't worked, and all you've done is, created a significant internal political problem. Secession in the UK Constitution, in some ways, if you compare it with other countries' constitutions, secession in the UK Constitution is really easy, because all you need to do is to persuade the UK Parliament to legislate for it. That's all you need to do. There's nothing else that's prescribed. There doesn't have to be a referendum. There are no particular conditions that need to be applied. It is as simple as that. You persuade the UK Parliament to legislate for it. Now, of course, it's not as simple as that, because how you get to that point is the $1 million question. How do you persuade the UK Parliament to legislate for independence? But there are many potential routes through which you could achieve that. A referendum has come to be seen as the gold standard route, and I think for very good reasons, because you're making a huge constitutional step. You want to make sure that it has the consent of the people, and it's been properly thought through, and all of those things. But technically, it's not required. So the plebiscitary election is an alternative mechanism. It used to be the SNP's policy until about 2001, I think, possibly slightly earlier. Their view, pre-Scottish Parliament, of course, was that if they were to win a majority of Scottish seats at a UK general election, that would give them a mandate to enter into negotiations. So, we're seeing this. I think that we see the plebiscitary election as an alternative way of trying to put that pressure on the UK government to come to the table and negotiate. But it doesn't come with any guarantees, any more than an advisory referendum does. Yeah. It's just a means of putting political pressure. And there are other ways that could be done, of greater or lesser degrees of problematic nature.
Yeah, I mean, there'll be people watching and listening tonight who take the view that there was a claim of right, which was endorsed by Holyrood and Westminster. On the basis of that, effectively there was an agreement there that the Scottish people were sovereign.
Yeah.
And they contend, since this was passed by both parliaments without demur, I believe, then they feel that that entitles Scotland to press ahead with whatever it so desires. And in addition, Margaret Thatcher agreed with the SNP position back then that you described. She said that if a majority of Scottish MPs are from the SNP, then that would be regarded as permission to negotiate.
Yeah.
So
these are
the sovereignty argument.
No, I think these are very important political arguments. So the UK Constitution, as you know, is an uncodified, unwritten constitution. Not everything in it is written down. Lots of it depends on conventions and other kinds of political understandings. So yeah, that sort of political acceptance of Scottish nationhood, of a right to self-determination, has always been important. But because it's political, because often not going anywhere beyond the kind of broad statement of principle, then the question of how you operationalize it, how you get from an acceptance of the sovereignty of Scottish people to the point of voting to become independent remains very, very vague. And I think one of the things that's been quite interesting about the attitude of the UK government over the past few years, where they've refused another Section 30 order. We've had an awful lot of now is not the time, or it was a once in a generation event, and or there needs to be higher support, or whatever condition I'm going to pluck out of the air today. What is rarely been denied, not never, but rarely been denied, is the right at some point under some set of conditions to become independent. So I think that is still quite important, that very few Westminster politicians, not none, but very few, are denying the foundations of the case. All of the dispute is around about timing, is around about conditions, is around about who has the right to determine when a referendum takes place. And that, that's a difficult position, because it's very difficult to keep postponing that, and if you're going to accept a right of self-determination in principle, to keep postponing the operationalization of it, to keep coming up with different reasons why, not now, but maybe at some point in the future, but we're not sure when. I think that's a difficult argument or difficult position to maintain into the long term. So at some point, clarification is probably required.
Yeah, it's interesting. I was chatting to Elliot Bulmer. He did a piece on the Sunday National about Malta becoming independent. And that whole process was hugely facilitated by the Foreign Office. Mm-hmm. They actually did the heavy lifting. They said, we'll produce a paper on a constitution.
Yeah.
So you might
regard the Foreign Office. The Foreign Office has a lot of experience in drafting constitutions.
Isn't that somewhat ironic? The Foreign Office, an arm of the British government, was a factory for producing constitutions without them having a written constitution itself. And they produced this written constitution for Malta. Mm-hmm. And the Maltese went ahead and voted on it, and the rest is history.
Yeah, so if the UK government, the UK Parliament wants to facilitate a process of independence or decolonisation, these are obviously different things. Scotland is not a colony; it's part of the UK. It has the power to do that. It's just a question of how you get to that point. And of course, the UK has experienced secession from by one part of the UK. Ireland, most of Ireland became independent through a process which was eventually agreed, but of course didn't start off like that. And that's one way, in not a desirable way at all, but it's one way in which you put pressure on the UK government to to come to terms. So that's what I said. That there's the key point is getting the UK Parliament to legislate for the referendum. How you get to it, there are a spectrum of more or less desirable ways of getting to that point.
I wonder if it was the Irish experience that John F. Kennedy was reflecting over when he said, if you make peaceful change impossible, you make revolutionary change inevitable. And that is my sense of it is that's what happened in Ireland, as you say, not terribly desirable. We've had a question from James, who says, essentially, if the Supreme Court says no, then it proves that Scotland is a colony.
Well, I mean, I don't agree with that. Scotland is not a colony. Scotland, I mean, colonies don't have representation in the UK Parliament. Colonies don't have, well, they have some right to self-government, but, we're not a colony. We're part of the UK, and that is an important difference. If the Supreme Court says no to a referendum, what it's saying is that it doesn't think that this is what was envisaged under the Scotland Act. Well, there's no plausible argument under the Scotland Act. The Scotland Act can be changed. Right? The Scotland Act can be, it can be changed in both directions. If the Supreme Court says the Scotland Act does permit a unilateral referendum, that can also be changed. I don't think it would be. I think that would be an incendiary step for the UK government to take, but it's legally possible. So the UK has a very, very flexible constitution, and flexibility can be very helpful in some circumstances. It can be very unhelpful in other circumstances. But I don't think you can say that just because a piece of legislation is interpreted as not allowing for something that means that Scotland is a colony. Devolution is a limited. The powers of the devolved Parliament are legally limited. We've always known that is in the nature of devolution. It would be in the nature of a federal system as well.
So answer this question, please. People have suggested on social media that in view of the fact that a referendum was entirely legitimate in 2014, why is the UK government challenging that situation now?
Well, there's a number of potential answers to that. I mean, so one would be that the UK government, the Cameron government, accepted all of the things that his predecessors had said, that you said earlier. Margaret Thatcher accepted the right of the Scottish people to become independent if they so chose. So that you could see it as a principled stance in 2014. You could see it as a principled stance that wasn't perceived as being terribly risky, because 2011, when the SNP won their majority, support for independence in the opinion polls was pretty low. Nobody would have placed money on the odds on a yes vote at that stage would have been very, very poor indeed. So it's easy to take a principled decision in circumstances where you think the risks of that backfiring are quite low. But I think that you've probably got that mixture of principle and pragmatism. Now, why won't they allow it now? Well, we're in a different situation in terms of the opinion polls. Public opinion is much, much more evenly balanced than it was back then. But you've also got, I suppose, a whole range of principled and pragmatic arguments against a second referendum as well. I mean, to play devil's advocate here, I know that this is maybe not what people want to hear, but frequent secession referendums are regarded as destabilizing. So if you look at the literature on secession, they tend to advocate quite long periods between them. Northern Ireland is a big exception to that, because there's only a 7-year interval between border polls in Northern Ireland, but let's put that to one side. And you might also say, of course, while we're going through Brexit and we've gone through COVID, that maybe the now is not the time argument did have some plausibility. But both of those sets of arguments become weaker the longer things go on. We're already 8 years after the first referendum. It'll be 9 years if a referendum is held next year. So, the longer you delay, the longer those kind of, the less plausible those kind of arguments become. And I think, the 50 years and things like that are pie in the sky, really. That's not, I don't think anyone would seriously argue for the 50 years should pass between secession referendums.
But the way we're moving just now is that looks like a likelihood, let's put it that way, if nothing stronger. Unless you're suggesting that it would be untenable for the UK government to say not now for the next 6 years.
Well, not now for the next 6 years is a different proposition to not now for the next 42 years. So 50, I said, not 15.
Oh, I beg your pardon. Sorry, I misheard you.
Yeah.
I'm so sorry.
So as I say, is 15 years between referendums reasonable? Well, maybe. Is 20? Maybe. But the longer you get, the less reasonable that position becomes. And if, public opinion continues to support for independence continues to rise, then it becomes more and more untenable, because you've got, the longer you go on, the more of the electorate had no choice, didn't get a vote in 2014. And so the democratic arguments for having a second vote become stronger.
I'd like to sum up now a little bit, just to summarize some of the things we've been talking about. And please stop me if I've misunderstood what you've been saying. That there's no way of knowing right now. You didn't say this, but I'm going to suggest it anyway. There's no way of knowing right now which way the Supreme Court is going to go, and it may take weeks. I hear before it delivers a judgment, and we could be into next year before that happens. But if they decide that no, it's not in the control of the Scottish government to have a referendum, that it becomes fraught with difficulty for the Scottish government to plough ahead with their own and hope that that works in any way, shape or form.
Yeah, that's right. I think if the Supreme Court says no, then the Scottish government simply cannot, as things stand, organise a viable referendum. It just can't. So unless there would need to be a further amendment to the Scotland Act, and I guess that would be, that might be somewhere where they would move to. There are arguments out there for, people talk about a UK Clarity Act on the model of the Canadian Clarity Act that specifies the conditions under which independence referendums can take place. What the franchise would be, what the interval would be, what the voting threshold would be. So that that might become one strand of opinion. But yeah, what this will do, if that is the outcome of the Supreme Court case, is to just push this back into the political arena. It has to become a question of political negotiation, and that has to become, that is a question of what kind of pressure the Scottish government can bring to bear on the UK government. And I would suggest that the key issue there is going to be the level of public support. If levels of public support rise to a clear and convincing majority, it is difficult. It's not impossible, but it is difficult for a UK government, with all this history of acknowledging the right of the Scottish people to self-determination, to keep resisting the exercise of that right. But there are no guarantees.
There are no guarantees. And also you mentioned that there could be some sort of Clarity Act. There'll be nothing to prevent, I assume, Westminster, the Parliament of Westminster deciding that there ought to be a fairly minimal constitution for the UK. And in that constitution, or it may not take that particular descriptor, but some form of legislation that echoes the Spanish constitution, which, if I recall right, asserts that the territorial integrity of the state may not be changed. That's a
yeah, it does. That's what the Spanish constitution says. I mean, the constitution can be amended, of course, but that requires a special process. I mean, the difficulty with that kind of position in the UK context is, of course, Northern Ireland, because it's written into the Good Friday Agreement that Northern Ireland does have the right to leave the UK and form part of a united Ireland if there is a vote in favour of it. And that right has actually been accepted for a century. Right back going back to 1922, the people of the Northern Ireland Parliament, as it was at that time, was given a vote on whether or not they wanted to join the Irish Free State, and it was the right of the Parliament to veto any attempt to get rid of Northern Ireland from the UK. That was written into a statute in 1949. It then became a referendum requirement in 1973 and has been repeated. So in the Northern Irish context, it is very, very well entrenched that there is a right for the people of Northern Ireland remain part of the UK only with their consent. And if they want to leave, they can leave. So any kind of solution that vetoed secession altogether in the UK context would have to contend with that position in Northern Ireland. So it could never be for the whole of the UK, unless you want to breach the Good Friday Agreement and reignite the troubles in Northern Ireland, which I would hope that no government would even contemplate doing.
But couldn't you easily pass an act that says this act applies to other constituent parts of the UK, but does not apply to Northern Ireland?
Well, you could do, but then then that raises a question of consistency. Well, why? And why would you have to be consistent? Well, because consistency is always a good thing, isn't it? If you're not consistent, it's incumbent on somebody who's not consistent to justify that lack of consistency. And of course, sometimes it can be justified. But it's not just Northern Ireland. I mean, we had a referendum on independence in Scotland in 2014. Why was it okay in 2014, but never, ever again? Really? I mean, that's, again, a difficult position to argue for. And I mean, you could say, I suppose, if you were so minded, it was a terrible mistake to allow that in 2014, and we're never going to do it again.
Yeah.
But I think that is going to be a position that's difficult to persuade a significant number of people of the merits. Although there'll be a lot of objection to that, I think.
Yeah, but I mean, if I was a
good thing.
Yeah, if I was an MP looking for promotion, I might want to suggest such legislation. I might say, look, we made a terrible mistake in 2014. Northern Ireland is a special case, and we should make sure that's properly recognised and honoured. But as for the rest of the UK, I mean, this is ridiculous. Why are we even talking about breaking it up?
Yeah,
there's a flaw in our constitution. We need to fix that flaw, and here's my proposal for fixing it.
Well, if you stick with the constitution based on parliamentary sovereignty, that can never be a permanent solution, because
exactly
you can legislate however you like, but we can't entrench anything, whether it's a negative or a positive proposition. So yeah, I mean, and as I was saying earlier, I mean, you do hear that kind of attitude, but it's not very widespread. It's still not very widespread. Most of the arguments from the UK government side on why no second referendum have been on the kind of now is not the time level, rather than no, never. There is no right, even in principle, to become independent. And I think, that there's a degree of that gives a glimmer of hope that that at some point now will become the time.
I mean, it does sound problematic, and some people have said that the Scottish government made a terrible mistake in going to the Supreme Court because all they've done is set lots of hairs running. It was completely unnecessary. They should just have stuck to their guns and said, you know, if we've got a majority, then we will keep asking the UK government to come to the negotiating table. It was completely unnecessary to involve the Supreme Court.
Well, I mean, they have been asking for another Section 30 order since March 2017 and keep getting the answer no. I mean, I think the Scottish government would have felt under some pressure to make progress on this. And the only way they can do that is to try to legislate by themselves. But to legislate by themselves, they have to overcome this hurdle of getting the Lord Advocate's agreement to sign off a competence statement, because a bill cannot be introduced into the Scottish Parliament unless the minister in charge thinks that it is within competence, and under the Scottish Ministerial Code, that requires the Lord Advocate's sign off. So, you know, the Lord Advocate has been in this kind of blocking situation, and what we've seen in the Supreme Court over the past couple of days is that she's obviously very uncomfortable being in that situation. She doesn't think that it should be her decision whether or not, you know, a referendum bill gets to be introduced or not. She thinks that that's a question that needs a much more authoritative answer, that needs to be argued out in public, to be justified in public. And I think, you know, I think she's right that, you know, that is highly problematic if one person can, you know, within the Scottish government, because she's not sure, can stop a bill going ahead. So, you know, I think that I don't think this was a mistake. I think this had to be resolved at some point. I mean, if they had introduced a bill, if it had been passed by the, well, it would have been passed by the Parliament, it would have been referred to the Supreme Court anyway. So, you know, get it over and done with sooner rather than later. And I hope we will get an answer on the substantive question. I think we will, even if the court decides the reference wasn't properly made. I think they will still express an opinion on the substantive issue, whether, i.e., whether that Holyrood can legislate for a referendum.
But that sort of means that that's a high, you could argue. I mean, I'm a businessman, and I would have regarded that as a high-risk strategy. I mean, why would you want to poke the wasp's nest when you could just as easily sit there and keep asking and asking and asking? As soon as you do what they're doing now, effectively, you invite a court to rule against you. In that case, you've made it impossible, really. Now, you could argue, well, whatever happened, you would still have needed somebody at Westminster to agree. Whatever the Supreme Court decides, you still need somebody at Westminster to agree that a referendum can take place. I mean, that's the case, isn't it?
Well, I mean, Westminster has to agree at some level. It either has to agree explicitly, as it did in 2014, because the Scotland Act was amended, or it has to agree implicitly in that it is already within the powers of the Scottish Parliament under the Scotland Act, which was passed by Westminster. They may not have said so expressly, but implicitly that power was already in there. So yeah, in that sense, Westminster's agreement is required. I mean, I think on the politics of this, I mean, I'm a lawyer, I'm not a political scientist or a political analyst. I mean, it seems to me that the Scottish government had to make some kind of progress. We were at an impasse, and the impasse needed to be broken somehow. And this, you know, even if the answer is a negative one, well, you've moved on, right? One issue has been resolved, and you can move on to onto something else. It isn't a good thing. I mean, is it a good thing to be stuck on process? From a tactical point of view, for the independence movement, in some ways it is a good thing, because, you know, the blocking of Scottish democracy has a certain traction in terms of driving support for independence, but it's undesirable insofar as it keeps us off the substance. While we're talking about process, how we get to a referendum and who can authorize one, we're not talking about what independence would look like and whether or not it's a good thing. And you know, ultimately, those substantive questions are far more important than the process questions. We need a process that's legitimate. We need a process that everybody can agree to, even if they don't agree with. But the substance is what really matters. And when process is getting in the way of substance, you've got a problem, I think.
Yeah. I mean, some people have said, you know, why, again, in relation to the Supreme Court, why not just go straight to United Nations and say, look here, you have a ruling on self-determination. We would like to exercise our rights under that ruling, and we want your help to do so. So, I mean, I'm going to heavily caveat this with I'm not an international lawyer, and I don't really know how the process operates of how you go to the International Court of Justice. But, I mean, the problem with relying on the international law right of self-determination is one that was highlighted in the Quebec secession reference that got a mention today right at the end of the Supreme Court case. In that case, the Supreme Court of Canada drew a distinction between internal self-determination and external self-determination. So internal determination is where you have a group of people, a group recognized as a people in international law, has a high degree of internal autonomy versus a people which is genuinely oppressed and has no self-determination at all. And the Supreme Court of Canada said it's only that second group, the oppressed, that have the right of external self-determination, i.e. the right to become independent. If you've already got a high degree of internal self-determination, then that is enough to satisfy the right of peoples to self-determination. So it doesn't necessarily that, yes, there is an international right of self-determination. Yes, it is probably the case that Scotland would count as a people in international law, but it doesn't necessarily follow that international law gives us the right to become an enforceable right to become independent. So quite apart from the fact of how do you take a case to the International Court of Justice? I don't know. I don't think we would win it if we got there. Yeah. I mean, essentially, in the Canadian situation, I mean, correct me if I'm wrong here, that Quebec, that Supreme Court judgment would have ruled out Quebec, but it may have included the Crow Nation in British Columbia, for example, if that's where they operate from. But possibly, yeah. But Quebec, already a province in a federal system with a high degree of autonomy, international law didn't help it. And as a matter of Canadian constitutional law, the court also said, well, you have a right to hold a referendum, but that doesn't mean that you have a right to secede from Canada, because that engages the interests of the whole country, of the other state. Well. Yeah. So all that it would trigger is a duty to negotiate, but those negotiations might not result in independence. Yeah. I mean, it's interesting that based on what you've been saying tonight, that the preferred route in all of these things in terms of secession is negotiation, is to get people around the table and say, look, this is what we want, this is what you want. Mm-hmm. We need to trade some horses here to make sure that you get as much of what you want and I get as much of what I want. Mm-hmm. And that's the preferred route. Yeah. Anything else is inferior to that. Yeah, I think that's right. That is right. Because anything else, well, you certainly don't want to go down a route that involves any kind of violence. That would be appalling. But you don't want anything, you don't want to set up a new
or re-establish an independent state in circumstances where you're on appalling terms with your nearest neighbor, where, you know, a large proportion of the population does not accept the legitimacy of the new state and still wishes to be, you know, part of the old state. You want a situation in which you have losers' consent. So the people who lose, they don't like the result, but they accept it. They accept that it's a legitimate result, and that, you know, that requires compromise. It requires careful deliberation. It requires a process that is regarded as legitimate. And it's frustrating. Of course, it's frustrating if you you know, if you really want something to happen, but if you want that thing to be successful, it is wise, I think, to try to go about it in a manner that is as legitimate as you can possibly achieve.
Also, we have to take on board realpolitik. I mean, if you look at the Soviet Union, when it fell apart, so all of a sudden places like Estonia, Lithuania, and Latvia would all be campaigning for independence and being told it's impossible, it won't work for you, you need to be run from Moscow, we'll give you some devolution along the way if that helps you, but nothing more than that. All of a sudden, overnight, they have their independence, it's recognized by the United States, they become members of NATO, all the rest of that stuff. And it happens quick. I mean, it's in relative terms. It sounds to me as it very much depends on the stability of the state itself. I mean, is the state stable, and therefore it induces a sense of adherence, which is somewhat emotional, perhaps, as well as strategic. And maybe that's a factor too, which is difficult to interpret, perhaps.
Yeah. I mean, it's difficult to generalize from other cases because they're, you know, they are different, aren't they? Catalonia is not the same as Scotland. Scotland is not the same as Quebec. We're certainly not the same as former Soviet republics or former British colonies in Africa. These are different situations. But I mean, I guess what maybe the collapse of the Soviet Union tells us is that life is awfully unpredictable, and we know that. And we've learned that. If we didn't know that before, we've learned that over the past few years, haven't we? So things can happen that you don't anticipate. And you know, we are kind of at that position in Scotland at the moment, that we're kind of waiting for, on both sides, waiting for the thing that will kind of change political fortunes. Clearly, the unionist tactic in delay is that they hope this will go away, right? They hope that either the SNP will lose power in Scotland, so the issue's off the agenda, or public support for independence will fall significantly. Again, the issue's off the agenda. So that's what they're hoping for by delay. But no sign of those things happening. The Scottish government, the SNP, have to hope for a piece of luck on their side, right? And what might that be? It's difficult to know, but it might be the outcome of a UK general election where they hold the balance of power, possibly. You know, who knows what it might be? But I think it is difficult to see the way out of this impasse. If the Supreme Court says no referendum, it's difficult to see what the way out is, barring some kind of unexpected shift of political fortunes on one side or the other.
Yeah, and it's difficult to see a change of political fortunes in Scotland because the settled will appears to be the way we discussed it earlier. Very different to 2014, perhaps, but fairly settled. Whereas when you look at the rest of the UK, it doesn't seem to be as stable as it was back in 2014. There's a sense of, I don't know,
chaos. Yes, it's extraordinary. It really is extraordinary. I mean, to put my kind of UK constitutional lawyer hat on, it's incredible. I mean, I suppose I'm somebody who grew up thinking that the UK had a competent system of government. And that's taken a bit of a battering, you know, that's a competent and you know, that people had people in public life had integrity and weren't corrupt and all of these things. And you know, it's harder and harder to maintain that view of the UK, because it does seem to be getting worse. You know, you go from Boris Johnson, who seemed to be awful, to somebody who is extraordinarily worse. I mean, so where do we go? Where do we go from Liz Truss?
Well, it's an interesting point, isn't it? And you know, it starts to make the arguments different now. There's a sense of there's almost a sense of sort of catharsis in some way. I don't know quite how to describe it, but things feel very different. I mean,
yeah. Yeah, in 2014, the Unionist side was playing very, very heavily on the strength and stability of the UK, particularly its economic strength and stability and its standing in the world. And those have taken a real battering, not because of anything that's happened out in the world, but through self-imposed, you know, self-imposed decisions, or self-imposed shooting in the foot, if you like, which is, you know, well.
Yeah, well, Aileen, we've covered a lot of ground. We're almost running out of time. Is there anything that you feel we ought to have said, or you would like to say before we close? Is there anything at all?
Not particularly. No, it's been a pleasure chatting to you. I've enjoyed it.
Well, like I say to all of our guests, if you find this material helpful, you want to use it for your own purposes, feel free to do so. It's very much in the public domain. Everything we do is out there. There are no hidden agendas. Everything is what you see. I noticed that Nicola Sturgeon, by the way, just in closing, has pledged that the NHS will be secured in a written constitution on independence. And we're having a poll tonight in which we're asking people, would you like to see a written constitution for Scotland? I'm not quite sure if the results of the poll are available, but if they are, we'll put them on the screen. But I found your remarks about the sort of uncodified constitution for the UK very interesting, because on the one hand, it provides flexibility, but maybe there's a lot of times when you actually don't need flexibility at all. And you need to.
Well, I mean, yeah. Flexibility is one thing, but not having a clue what the rules are, or not being able to enforce the rules. Yeah, I mean, one of the things we've seen over the course of the Brexit process is just a kind of collapse of common understandings. One example would be the Sewell Convention, the way that we understood that to operate and what it meant has been completely turned on its head. You know, and it barely seems like a rule anymore. I think if it wasn't written into the Scotland Act and the Wales Act, we might not even be talking about it as a convention, because it just, you know, is so easily overridden. But you know, there's been a lot of that things that seem to be fairly solid and certain turn out to be, yeah, much more flimsy or less well founded than we might have thought. Yeah,
we have a saying on the show that the British Constitution can be described in one sentence: it is whatever the government of the day with a working majority says it is.
Yeah.
That might be taking it too far, but that's a big thank you. Let me just say very quickly what the results of the poll were. And 96% of the folks on Facebook, 96% of the folks on YouTube felt there ought to be a written constitution. 86% said yes to a written constitution on Facebook, and 96% said yes to a written constitution on Twitter. So far, over 500 votes.
Yeah, well, I mean, in an independent Scotland, I think we will have a written constitution. I think there's no question about that. So, yeah, the real interesting debates will be what's in it, what kind of constitution is it, and what does it contain.
Well, the sooner we start that debate, the better, perhaps. A big thank you, Aileen. Many, many thanks indeed. I hope all our audience have enjoyed it as much as I have. We're here to educate, inform, and entertain, and I think we've achieved all of that tonight. Big thank you to you. If you can stick around, I'm about to make a few concluding remarks, and we'll just bring things to a close. Big thank you to Aileen, obviously, and a big thank you to all of you out there for joining us tonight. We've tried to answer as many of your questions as possible. A few of them had been answered earlier, and obviously we're not going to go over some stuff we already dealt with. As ever, we have a formidable list of guests lined up for future shows. As you know, this is the place for the big hitters, as you've seen tonight. Remember, Indie Live, you'll find all the details on the whatsonguide.scot. We're back next week, October 19 at the same time, and we'll be joined by Emma Roddick, MSP. Your questions for her, as soon as you have them, let's have them, please. And please look out, again, a reminder, for my column in the Sunday National this weekend. And I'll be talking a little bit about the Supreme Court, but a lot about other stuff as well, about morality and ethics. When did you ever hear that discussed in politics? And as I say always, it's been a great day for British democracy. Tory MP Laura Farris wants to solve England's energy crisis with fracking, but she doesn't want it anywhere near her Berkshire constituency. When she was asked where that fracking might take place, she said, there must be somewhere in Scotland where it could happen. Why? How to make friends and influence people. Look for the crowdfunder, everyone. And to all of you, thanks for joining us. Stay safe, take care, look after each other. See you next week. Good night.